Asking for a Friend, the law you need to know, by butlerfirm.com.
Hi, I'm Jeb Butler of the Butler Kine Law Firm, here with you for the Asking for a Friend podcast and videocast. We do personal injury work here at our firm, so it's always interesting to talk with friends of mine who practice law in other areas, because I learn a lot talking to them, and I hope that you will too. Today, we'll talk with my friend Brett Switzer, who I know not through any legal channel, but because our kids played baseball on the same 3- and 4-year-old team. So in the middle of chasing children around a baseball diamond, we got to know each other a little bit. Brett's practice is in white-collar defense, and we'll talk a little bit with him about what that is. But basically, he helps folks when the feds get after them. He practices law at a firm called Berman, Fink, Van Horn, which is a really well-regarded firm here in Atlanta, Georgia. And they focus on being an asset for businesses from like the start of a business all the way through the sale of the business, labor and employment, the whole thing. But Brett's specialty there and the practice area he leads is in white-collar criminal defense. So I'm excited to talk with him. I think it'll be a good talk. So Brett, thank you for joining us.
Thanks for having me, Jeb.
Yeah, Brett Switzer, importantly.
Schweitzer's how we say it. At some point along the line, I guess my ancestors over at Ellis Island dropped a few letters off, the Albert Schweitzer spelling. But and there's a funny story. When I was a baby associate at a big law firm, I got invited to court for a hearing. It was a motion for summary judgment or something I had worked on very minimally, but it was nice that the partner invited me to come to court to hear the argument. And so the partner introduced me as Brett Switzer, his new associate. And of course, I never correct anybody, but here's where it got a little bit tricky. The judge, federal judge, said, "Well, Mr. Switzer, stand up and make an appearance on behalf of your client." And so I stood up, and without thinking about it, I said, "Brett Switzer on behalf of ABC client." And the judge said, "Well, is it Switzer or Schweitzer?" And so from that day forward, the partner that I worked on, described that as the time that I upstaged him, or I don't know what it was, but made him look silly in federal court. So
and when you're a young lawyer, that's a couple things that tense you up a little bit, being in federal court and making your partner look funny.
That's right.
Yeah.
It was just a funny little story, but yeah, we say Schweitzer. Thank you.
But now you're no longer worrying about what the partner thinks of you. Now you are the leader of your practice group at your firm.
That's right.
Tell us about that.
Yeah, no, very excited. In the past few months, I've joined Berman, Fink, Van Horn. Excited to be there. The firm's been around for 25 plus years. It was important for me to join a firm that's well established, well reputed. To a person, everybody I've talked to about the firm has very great things to say, and so makes me proud to be a leader of the white collar investigations and enforcement defense group.
So let's talk about that. I hear white collar defense, and I think most folks imagine that like, all right, he must just defend fancy people. Is that true? How would you describe what you do?
So yeah, it's a good question. White collar encompasses a broad range of subject matters and topics, and so the common denominator, as I view things, is that it means the federal government's on the other side of the equation, either investigating or enforcing laws.
Okay.
So for the client, what does that look like? Anytime a federal government agency, 3 or 4 letters, usually has an agent show up and knock on the door and ask for an interview. That would be a time to get a white-collar practitioner involved. Anytime you receive a grand jury subpoena, a civil investigative demand, anytime you've got the federal government, either through an investigating agency or an assistant United States attorney for the prosecution team reaching out and trying to investigate, you'd want to get someone like me involved.
Yeah, your clients are those that the feds is after.
That's correct. That very simply put.
And you mentioned the four-letter agencies or three-letter agencies. I know from talking with you that you've recently tried a case where the IRS was going after some of your clients. My grandmother used to work for the IRS. Maybe I shouldn't have said
God
that
bless her.
publicly. Anyway, rest her soul. So what other agencies are we talking about here?
Sure. Common ones would be, SEC.
Okay. And you ain't talking about the Southeastern Conference.
That's right. No, Securities Exchange Commission.
Okay.
Federal Bureau of Investigation, FBI, everybody knows that one. DOJ, Department of Justice. I've got environmental cases involving ENRD.
ENRD? I don't know what that was.
Environmental Natural Resources Division.
Okay.
I've got, trying to think what I've been working on recently, immigration cases. So Homeland Security Investigations, ICE.
What about
very
ATF?
ATF. Not one that I've encountered.
My family has a disreputable past. My uncle used to work for the Bureau of Alcohol, Tobacco, and Firearms.
Sure.
ATF.
Yeah.
Did some work with them.
No, there's lots and lots of them, but we've covered kind of some of the big ones.
Okay, so in terms of, let's see, I forget what I was going to ask you. These folks would start an investigation how? I mean, I've seen the movies where like doors are being broken down and they're raiding a house. Sometimes really polite. Might I just get a letter? Like, how does a investigation by one of these branches start?
Yeah, so my clients are frequently companies or a company's executive or employee, for example,
Okay.
right? And a company might receive, they might be served with a grand jury subpoena that says you are to appear and provide documents to or testify before the grand jury in an investigation involving, insert whatever the investigation may be. And so if you receive a subpoena like that, that'd be a good time to get a lawyer involved. The first thing I would do is reach out to the prosecutor, the assistant United States attorney, and try to understand more about what it is.
The first thing you would do, like you, Brett Switzer, the lawyer, not the first thing I should do as the person being investigated.
Right, the person that receives that subpoena or the outreach from the agent knocking on the door or serving and executing a search warrant, the first thing they should do is call a lawyer.
Okay, with the lawyer. Because I imagine we got this like alphabet soup of agencies, half of whom my family has worked for. But they're all going to be, every time they bring a case, I would imagine using the same group of assistant United States attorneys. Is that fair?
Well, so that depends on where the jurisdiction that the case is being prosecuted out
Do you
of.
see the same AUSAs over and over again? Have you become familiar with that office?
Here in the Northern District of Georgia, sure, very familiar with lots of the prosecutors down there and the supervisors all the way up the chain, to the United States Attorney, Ryan Buchanan. So, yes, in our home turf, I certainly know lots of folks, down there in that office. It's a growing office. It's a big office, but yes, having somebody that's familiar with, the prosecutors that's a good head start for sure. Now, a lot of these white-collar investigations are multi-jurisdictional. For example, I've been a part of lots of cases where an investigation starts in one jurisdiction and a prosecution, an indictment is returned in a different jurisdiction for any number of reasons. The prosecutors have pretty wide latitude, about where they're going to bring the case. But so it's not always that, a case begins and ends right here in your, in your backyard, but it happens.
Move around.
Yeah.
Okay. Let's take this back to sort of a personal level. I'll ask you this way: what are some mistakes that your clients have made that were avoidable? That you like? That if I get arrested, if the FBI knocks on my door, stuff I should know not to do.
Yeah. So, and this will be the most basic answer probably, but what should you do? You should be polite and courteous to the agent first and foremost.
Why?
But,
I don't like them.
well,
I'm pissed off.
in my experience, there's no reason to create enemies or cast aspersions. I think just a courteous engagement is always a step in the right direction. But where that should quickly go is that that you as the client want to have a lawyer represent you. You want to talk to a lawyer before you respond to any questions from the government. And that's your right, and nobody can hold that against you. Mm-hmm. And that's why I prefer to have these encounters be courteous, because I think that softens the the next part of the encounter, which is I'm not going to talk to you. I'm going to have my lawyer call you because I know that's the right thing to do. And at that point, the agent should honor that request, and you should get on the phone and contact somebody.
I feel like a lot of folks worry that, look, the agent's here, I think I can explain everything. If I say I've got to talk to my lawyer, they're going to know I'm hiding something. I'm going to end up in more trouble. Why don't I just explain it right then? Maybe they'll just go away and leave my doorstep.
Yeah, so that's just not how these things work.
Okay.
In my experience, no matter what you say, it's going to be the wrong thing to say, and it will be used. This is cliche, but it will be used against you, and I've seen that over and over again. Usually, what gets my clients in the biggest binds are the words that they say, the statements that they make in response to the investigation, the prosecution team. It's the things that, the questions that they try to answer, their answers, although they're truthful and completely innocuous, they get turned around and used against them in ways that are hard to untangle after the statements are made. And that begins from the time that the statements are made to your bond hearing, to statements that are going to be used against you at trial. I've never had a case where somebody answered a question and that was just it and it's all over. And
I'm sorry, Mr. Butler. I'll leave now. That didn't happen.
I've never seen that one.
Okay. I guess it can't help talking to the feds. I mean, they're there for a reason. They're not just going to leave.
Well, here's the thing. 9 times out of 10, my clients are going to cooperate with the investigation. We're going to do everything we can to cooperate, and hopefully have minimal involvement with the investigation, right, going forward. But so it's not that it's not that I'm suggesting that we're not going to be cooperative. I think you want to be cooperative, with advice of counsel and have, counsel involved as a buffer between you and the investigation.
And by counsel, you mean a lawyer?
A lawyer, yep.
All right.
Now, one more thing, because you asked what's one of the silly things, that gets people in trouble. And so one more thing that I see over and over again, it comes up way too often. So do not talk on jail phones. If you find yourself under arrest, if you're being detained, use the jail phone to call your lawyer and set up a attorney-client privileged call on a non-monitored line.
You mean they tap the phones in there?
They're listening to everything. I trust that they don't listen to the attorney-client non-monitored lines. I can't be certain of that, but I know they're listening to the general calls, and there's a disclaimer, you've probably heard it, that this call is being monitored. And so even if you're talking to a lawyer, I've been involved in cases where the prosecution, I start the call by saying, anybody that's listening, I am the lawyer, this is an attorney-client privilege call, but I've had prosecutors take the position that that's a waiver because everybody heard the disclaimer at the beginning of the call. Yeah. So use that call. Call your attorney if you need to call anybody else that's worried about you, your family, your significant other. You just tell them that you're getting in touch with a lawyer, and that's all you can that's all you can really share at this time. But talking about the charges, talking about the facts, and any of that stuff just gets people in deeper water.
So if I get picked up and housed at the the federal facilities, I can't tell my wife what's going on. I got to call and say I'm in jail. I need you to call Brett. But other than that, that's all I can say.
Well, I think that's the most advisable course.
What about in person? I mean, if someone is locked up, but say my wayward cousin gets locked up and I go to visit, I mean, could the police be recording, and could they later use against him anything that we say in person in one of those little meeting rooms?
So I'm not certain about at your county facilities and things like that what they're doing. I've definitely been in facilities in some of my federal cases where I know that there's monitoring going on. I know that there's video, at least surveillance of the rooms, some of the rooms that I've been in, and so. But if you set up an attorney-client privileged meeting, those should not be monitored.
Okay. But they could monitor you talking to your mom, your wife.
Absolutely.
Anybody else?
And I've had situations where people get on the phone or they on the phone is typically how this comes up, and they say, Mom, it's not good, I'm in trouble for whatever the case may be, and if they just go look if they just go look there, it's going to get a whole lot worse. And so guess what the FBI goes and does next?
That's where they look.
They look right there.
Wow. I would bet that objects that look something like this play a large role in a lot of your cases these days. Is that accurate?
Those cell phones are getting a lot of people in trouble, and they're
Put mine away then.
Our whole lives are on cell phones, right? So these are treasure troves of information for whoever wants it.
Right.
And in the hands of a prosecutorial agency, it's what's in there is going to be used against you. It'll be, perhaps taken out of context, perhaps used in context, but yeah, I see phones like that are encrypted get broken into all the time. There's developing case law about encryption and what is allowed and what violates Fifth Amendment rights and such in terms of cracking into these types of cell phones. And it's all because this captures all of our movements. It captures everything we do.
Yeah, we use them in our personal injury cases too. The defensive stuff you can track people sometimes, as you know.
Yeah.
All right. Well, we've talked a little bit about you. You represent individuals or businesses that are being investigated, and that's the practice area that you lead at your law firm. But it's not all that your firm does. They'll do a lot for businesses, I think.
That's right. Yeah. So our firm, we're there to handle and advise at any phase of the business cycle. So businesses and business leaders come to us to help from, starting a company all the way to
get investigated by the feds.
Well,
Which hopefully is not the end.
most of our clients hopefully never have to deal with that kind of thing, but we're able to. If you get a lawyer involved, the right lawyer that knows that's worth their weight in salt. Most investigations, I would say, in my experience, don't end up. They don't have to be catastrophic events. And so we do, help with all kinds of things in the middle. Where I was going with that was, a company exit from the business, a sale, a disposition, a breakup. If business owners can't see eye to eye, that type of thing, and everything in between, all your typical labor and employment issues, contracts, enforcement of contracts and obligations, those types of things. There's a group that specializes in enforcing, really in litigating over non-competes, non-competes, restrictive covenants, and trade secrets. Firm's very well known for that work and for being a leader in that space here in Georgia and around the country. We've got a great real estate group. But yeah, it's a general needs firm, and we advise all different kind of clients, but lots of businesses and business owners.
What size businesses are you normally working with, if that's a cognizable question?
Well, so we have clients, I'm working on cases with clients that are single-owned and operated, small family business type businesses with maybe a couple $1 million in annual revenues, all the way up to Fortune 50 companies. So,
wow.
It runs the gamut, and we're a little unique. We take on very small matters, so in the context we were just talking about restrictive covenants and non-competes, we advise all sorts of individuals when they're thinking about a new job, a new role, that type of thing.
Okay.
No case or matter too big or too small. We kind of run the gamut there. So,
yeah. I thought of one other thing I wanted to ask you about, then we'll let you go. But you and I were talking before we started the podcast, and you mentioned clients of yours who had to deal with federal agents wearing wires. And that's interesting. I mean, I've seen that happen in movies. I've not dealt with that in real life. I mean, how would that happen? How have you seen that play out when the government is sending people in with like a wire to try to, I guess, get information to incriminate?
Sure. Well, so the example that comes to mind is one from a trial that I handled last year. It was a criminal tax case, and it involved syndicated conservation easement transactions, which is a fancy term for partnerships were created and at the partnership level took tax deductions that flowed through to investors that claimed those tax deductions on their individual tax returns. The subject matter bored our jurors to tears.
Well, how long was the trial?
3-month-long trial.
About taxes. That's tough.
Now the jurors, they really enjoyed the confrontational aspects of the trial. So, when we cross-examined government witnesses for 9 weeks, they seemed to perk up, when it was our turn. But the government put on a lot of tax returns and appraisals and all the documents that support a case like the one that they brought, which was predicated on allegations that there were fraudulent appraisals, so fraudulently inflated appraisals that were supporting fraudulently inflated tax deductions. It was a fraud case. And a key part of the government's case were the recordings from wired communications between an undercover agent and my client and other co-defendants.
Who's the undercover agent? Is it like a fake? Someone who claims to be looking for a conservation easement tax break? And
That's
like,
exactly
hey, what can you do for me?
That's exactly what the undercover agent was in this case. So
they're lying about who they are. And
somebody with a completely fabricated identity, and in fact, they try to keep their personas or the aliases unknown to the public. They have to, right, for their own safety. So at trial, that becomes an issue. Our client knows he has one thing, but we weren't allowed to call the agent by that name because the government needs to preserve his ability to be out there in the field investigating, covertly. It's all a thing. But you asked about the importance of that testimony. Well, so there's allegations that appraisals are inflated, right? Mm-hmm. Well, they're trying to come in and get your client to admit that they know that the appraisals are inflated, right? And why do they have to do that? Well, in a criminal tax case, there's a heightened mens rea standard, right? The government has to prove not only that the conduct is illegal, but that you knew it was illegal and you still did it, right? So in a case that had millions and millions and millions of documents, they still are sending in an undercover agent to try to get you to get the smoking gun, right? To give yourself up. Well, so in our case, we put up an entrapment defense. This undercover agent contacted our client some 60 plus times. This is all part of the public record, right? So, and our client finally answered the call and said, "Okay, whatever, give him whatever unit he needs. Take it from my shares." And I think that's how the evidence played out. So, something along those lines. But the point is that the undercover agent, it would stop at nothing, right? My client didn't want to take his call, wasn't interested in taking the call, didn't take the call, whatever the case may be, right? It took like 60 contacts for this guy to come in and get whatever the big admission was that he was looking for, and it wasn't what the government, it wasn't exactly what they were looking for, but I'll tell you what, it's impactful testimony for a jury, right? The jury sits there for 9 weeks, and when you interview the jury after this trial, this is not what you want to hear, but some of the jurors say, well, we wouldn't have been here for 9 weeks if there wasn't something going on here. The government wouldn't have gone to these lengths if there wasn't something going on here. And that's not your presumption of innocence. That's not justice being done. But
right.
But it's impactful testimony. Anytime you've got wire statements, that's a huge deal at trial. The defense is moving to get those out, and it's no matter what it is that's on those statements, the jury hears them and thinks there's something wrong.
Yeah.
Yeah.
Wow. Well, thanks for joining us.
Yeah, thanks for having me, Jeb.
Appreciate your time.
Yeah, always great to be with you.
Cool.
Thanks for joining us on Asking for a Friend, the law you need to know. Find us online at www.butlerfirm.com.